All right, very good. Well, if Media Services wants to turn us on. All right. Well, I want to welcome everyone to the House Judiciary Committee. We have a full agenda today. We'll go ahead and begin with Senate Bill 9, presented by Chairman Fleming. Chairman Fleming.
Thank you, Mr. Chairman. The committee's well familiar with Senate Bill 9 and that we've already passed it out once before. Deals with the Augusta Judicial Circuit with Columbia County, my home county, being its own single county circuit, and Richmond and Burke remaining in the Augusta Judicial Circuit. When we passed the bill out of committee, there was a floor amendment in the Senate offered by a supporter of the bill, Senator Harold Jones, a minority whip in the Senate, who actually spoke in favor of the bill and his amendment, which was adopted unanimously, but it had an unintended consequence. This change we've made today that I'll point out to you simply corrects that. If you look on page 5 of the bill, lines 90 through 97, the minority whip's amendment added to the bill the name of the current district attorney, Jared Williams, but he added it in such a place where the other judges were. And the rest of the paragraph, when it talks about the judges, says that they will run in a nonpartisan election. We all know that in Georgia, our district attorneys are partisan and they run in a regular primary and general election. So inserting lines 91 through 97 leaves the name of the district attorney in the bill as the minority whip requested, but it simply says that he will be elected through the normal process for district attorneys. And that, Mr. Chairman, is the only change in the bill.
Thank you, Chairman Fleming. Any questions for the chairman? Hearing none, of course, the House sponsor, Representative Newton's out today with a death in the family. So we appreciate you standing in, Chairman Fleming.
Sure.
All right, seeing none with that, what I'd consider a technical change, a bill that already passed out of Judiciary, I'll hear a motion.
Do pass.
There's a motion and a second. All right, any amendments? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, bill passes unanimous. On to rules. Next bill up is House Bill or Senate Bill 221, and let's see, is Chairman, can you make it? So Whip Kelly will be presenting Senate Bill 221. While he's stepping up, we have some great bill summaries that have been put in each of your folders today, and those have been prepared by law students at Mercer School of Law, my alma mater, and they were interested in helping out the House Judiciary Committee this year, and so they've given us some nice summaries for you to use if you'd like to reference the bills. So, Mr. Whip, we will proceed when you're ready.
Chairman, I haven't had the chance to review those summaries yet, but knowing that they're coming from the same law school that produced our chairman, I know they're great, fine working order. So
that's right.
Thank you, Mr. Chairman, member of the committee. I'm here to present Senate Bill 221. I'm working off of LC 280192. It's a bill that creates the term leadership committee, in which can be defined as 8 different types of committees for the purposes of fundraising and fund expenditures as it relates to campaigns. We have worked very hard to make sure that both of the main political parties in Georgia are treated the exact same in this measure. So these leadership committees would be available to the governor, as well as the other party's political, the nominee of the Democratic Party, the current lieutenant governor, and the nominee for the Democratic Party for lieutenant governor. These leadership committees would be available to the majority and minority caucuses of both the Senate and the House. And so that's how we get to the 8 committees there. What these committees will be allowed to do is raise funds in any amount, and then be able to work with candidates directly on those expenditures. It has some important reporting requirements, Mr. Chairman. We believe that sunshine is always great for this process. And so after raising $500, any of these leadership committees would have to report and the same way that we do and on the same schedule as we do. And then when they expend money, it says that there should be a disclaimer that these funds are coming from one of these leadership committees as well. Mr. Chairman, it's a pretty simple bill, but I'll be glad to take some questions.
You have a few questions. Representative Wilson online.
Thank you, Mr. Chairman. Whoop Kelly, can you
Me up.
hear me?
Yes, now we got you.
Thank you. Thank you, Mr. Chairman. Whoop Kelly, can you clarify for the sake of everybody what would this allow in terms of contributions that is not currently allowed under Georgia law? Why do we need this?
So it would allow both the House and the Senate majority and minority parties to coordinate directly with their candidates for purposes of campaign expenditures for the funds they raise through. We call it our trust. I'm not sure what y'all are calling it, but it would allow for the direct coordination.
Are there limits placed on the contributions?
Currently, our trust, for both parties, neither of us have limits on how much can be given to us at any time. The only change is the ability to directly coordinate.
And are the donors disclosed?
Yes, after $500 of funds are raised, they have to then file the same disclosure requirements that we do and on the same reporting schedule as we do. And additionally, for any expenditure, it will have to say that these funds are coming from the leadership committee.
Thank you, Mr. Chairman.
Thank you.
Chairwoman Oliver.
To be accurate to say that this increases the impact of money on politics rather than decreases the impact of money on politics.
I disagree.
Well, if it's creating a additional new funding source, how could it do anything but increase the impact of money on politics?
It's not a new funding source. It's a new funding expenditure. Right now, our trusts can both raise unlimited amounts of money currently, but we're just not able to directly coordinate with our candidates.
So it incentivizes your donors to have more direct impact on candidate expenditures. So that would support my position is that this incentive is a greater impact to support money in politics rather than reduce it.
No, I disagree. Right now, this does just eliminate a step in the process of having to work with another group to expend the monies that our caucuses are raising. I think as you know, again, we worked very closely to try and be fair here. And I think that the money that y'all raise as a caucus, that y'all should be able to directly expend on getting members like you reelected. And we ought to have the opportunity to do the same without a outside group having to be in the middle of that expenditure.
Final question, Mr. Chairman, if I may. Fair to say that the Senate race in January runoff of January 5th was totally unlimited money by both parties. Totally unlimited money by both parties.
I agree, and that didn't work out so well for us.
Representative Evans.
Thank you, Mr. Chairman. In our law, somewhere along the way, before many of us were here, both in federal law and state law, we've decided as a policy position that we have these third-party groups that raise money and they do what they do, but the law has always said they do not and should not coordinate with candidates. What is the policy reason for now wanting to let third parties directly coordinate with candidates, and what changed to want to make such a big policy change in election law?
Right now, as I'm sure you know, when we raise money as a caucus to then be able to coordinate and expend it, both parties usually work then through their respective state parties. It's just a cumbersome process. And I think giving both of our caucuses in the House and the Senate the ability to coordinate directly with the candidates that they know best, they know the races best. I think y'all's leadership knows y'all's candidates and the races better than necessarily having to go through anyone at y'all's state party. I feel the same for us. And so that's simply all it does. It doesn't change the amount of money our caucuses can raise. It doesn't change the disclosure requirements. It just simply allows for the direct coordination of our respective caucuses, campaign committees to be able to be expended on our members. The money we raise, we ought to be able to work with our membership to then distribute.
One more question, if I might, Mr. Chairman.
Yes, ma'am.
Would you say that this law would dilute the influence and power of the state parties then? in our legislative races?
Not if they're doing their jobs the way they're supposed to be.
And what would that be?
I think our state parties have the ability to go out and raise funds specifically on their own, and use that effort to support the races that are important to them. And I think our caucuses should have that same freedom of being able to raise the money that we feel is necessary, and then us work directly on the races we feel are important.
Thank you.
All right. Representative Walensky.
Yeah, my hand is raised, but I don't know how to work this thing.
I'll come to you next, Representative Bruce. Representative Walensky.
Thank you, Chair. When I ran my race, I raised all my own money and did it on my own. So I'm just wondering, can you just explain to me, because I'm not in your party, explain just the dynamics of exactly how this works, who's raising the money, and then how it's used, and can you just explain that to me?
Yeah, well, I'll tell you, if you'd have ran as a Republican nominee, we would have helped you raise money, and we would have helped make you get some too. And that offer's always open to you. But
I don't want to take Sheriff Stration's position, so I'm holding off.
for us, we have candidates that certainly raise money for themselves and they spend it, but we also raise money as a caucus, and then we have to send it to the state party, who then spends it on races we encourage them to, but not necessarily the way we would maximize that. And I would think y'all had a similar structure in place over there, but that's how it works, at least on our side.
So the leadership committee, does that mean anybody who's running for these positions or is in these positions get to select who's in that committee, who can get the funds? Is that the idea?
So obviously it's pretty easy for the statewide offices, for the governor and then the nominee from the opposing party for governor and lieutenant governor. They would be able to obviously raise and spend the money directly there for themselves. For us, in the terms of how we operate, at least on our side, in the House and our caucus, every caucus probably does it different. But on our side, we have a core group that helps make those decisions of how we raise money and how we expend money, and that would be the group that makes that same decision for the leadership committee. I imagine both of us would end up amending our caucus rules to account for how those people were selected.
Representative Bruce.
Yeah,
follow-
sorry.
go ahead.
I'm
Sure.
just trying to understand this. Sorry, Chair. Two more questions, I think.
Yeah.
One is, so who the money would go, the leadership committee would be able to raise money and disperse that directly to state house and state senate races.
Yes.
Who makes up a leadership committee?
So I think that would be addressed in your caucus rules.
And is two more questions, Chair. Is there a limit on how many committees can be formed that can do this?
Yeah, each caucus would get one leadership committee, just like y'all. I assume there's a Democratic House Trust. Ours is called the Georgia House Republican Trust, and the governance of that trust right now is determined by our rules. I imagine y'all would have the same, and that's how this leadership committee would be determined.
And is the two more questions? I think I'm almost done. Does the
You
leadership
said that
committee?
2 questions ago.
I'm an attorney, you know that. Does the leadership committee is it comprised of people already elected to office?
That would be a decision that was made by, again, your caucus. I'm always glad to come visit with y'all and talk through what I think would be the best way to do it. But on our side, like most things, the speaker will be the head of ours.
And so if a party decided that people elected were in charge of this leadership committee, would you agree that this would give a lot of financial power to people elected on who else is coming in?
I know that we wouldn't do that in our caucus. I would hope y'all wouldn't do the same. I would hope that right now you could do that by giving it to someone. Right now that happens through the state party system. Right now, what we're trying to do is something that I would think all of us in the House, in this legislature would want to do, which is give ourselves some authority back.
Representative Bruce online.
Yeah, I just want to get clarity on something too. Candidates running, you have 2 or 3 Republican candidates running against each other. Are you saying that you would be able to raise money and give all of those candidates money unlimited?
This is saying that, and again, you think you're going to see your caucuses take positions on how you want to do this. One, this does not impact any federal race. Let me just be clear. This would have no impact on any federal race. We can't determine federal election law. So what we're talking about here is we kind of have some rules for our caucus on how we decide to engage or not engage truly in contested Republican primaries generally. And so we make that determination as a caucus today. And I would think y'all would as well. But if at every time y'all wanted to expend money for, in a race where you had 2 Democrats in a primary, you could do that through this leadership.
But are you saying you're going to give them money directly?
You can spend money on their behalf directly. You can't give to their camp. Let me finish. You can't give them a donation to their campaign directly outside of the spending limits for their personal campaign. But you could spend money on their behalf in a coordinated effort.
So you could run ads for them, and
that's correct.
All right. I don't see any other questions. Is there a motion? Is there a second? There's a motion and a second. Any amendments? Hearing none. All those in favor signify by saying aye. Any opposed?
No.
Yes, no.
In the opinion of the chair, the ayes have it.
Can we take a
Chairman, can we have a,
Division's
Chairman, can
fine.
we have a
All right,
hand
all in
count?
favor? All in favor, raise your hands. Any online in favor? Please state your last name.
I guess, Mr. Chairman, while we're having this vote, can I ask the Democratic Party if they'd like to be left out of this measure? You want to vote against it?
Well,
That
we'll go ahead.
doesn't have to be answered.
We're not hearing any rhetorical question from the whip. We're not doing parliamentary inquiries in judiciary today. All right. Any in favor online? Hearing none. All right. And all opposed in the room, please raise your hand. All right. All opposed online, say your last name.
Bruce.
Holcomb.
Okay. So it passes 9-5. Okay. Representative Wilson was muted. It passes 9-6. All right. Bill's on to rules.
Thank you, Mr. Chairman.
Thank
Members of the
you.
committee.
Next bill we'll call is, if Senator Hatchett is in the hallway, if he would come on in. Senator Hatchett, if you'd come on up front and center here, and when you're ready, go ahead and present your bill.
Thank you, Mr. Chairman. Today I bring you a bill I like to call the Taxpayer Fairness Bill. And this is a bill that Subcommittee Chair Scoggins heard last week, and we got it out unanimously. For the attorneys in the room, I don't mean to bring up bad memories of law school, but if you can remember the Chevron case and Chevron deference, that is a deference that the court has when a statute is ambiguous to refer to a regulation. Beyond Chevron deference, there's something called sub-regulatory deference. And when dealing with sub-regulatory deference, if that regulation is further ambiguous, then they can defer to the department for their interpretation. And as long as it's reasonable, they defer to that interpretation. So I've got to back up just a little bit. The reason I call this a taxpayer fairness bill is right now, when you walk into a tax tribunal, if you're challenging a regulation that is ambiguous, they automatically refer to the department's interpretation. So as a taxpayer in this situation, you're facing an uphill battle. What this bill intends to do is to level the playing field. There was a more aggressive approach last year, and we have a compromise bill here that all parties have agreed to, including the DOR. I'm not sure if y'all have the letter from the department.
Take it out. I know that we had letters of support from the Department of Revenue and the Georgia Chamber of Commerce.
Yes. And those are,
I'm not sure if they're in the folders, but if anybody needs that, you can get it from my office if you need those.
But that's it's a complex bill, but that's a simple way to put it. It's leveling the playing field for taxpayers in the state of Georgia.
All right. I know that this came out of the Scoggins subcommittee. Chairman Scoggins, do you have any additions to add?
I co-sponsored the bill last year. I think it's a great bill.
This issue was heard
Yes.
in Judiciary
It was
last,
vetted
well,
in subcommittee, yes.
similar issue was
Yes.
heard last year. All right. Any other questions for the sponsor? Chairman Burchett. All right. All right. I don't see any other questions. So there's a motion from Chairman Burchett. Good.
Do pass.
There's a motion and a second. Any discussion, amendments? Hearing none. All those in favor signify by saying aye. Any opposed? All right, bill is on to rules.
Thank
Passes.
you very much.
Thank you.
I appreciate it.
All right, next bill we'll call Senate Bill 163. Chairman Strickland, good to see you today.
Mr. Chairman, I brought my binder of all the House bills we're about to hear in Senate Judy in about 10 minutes.
What's
So
up?
I thought it may help me get things out of here a little quicker today,
Good.
hopefully.
Glad to have you today here,
Good.
Mr. Chairman.
Good to be here. Yeah, most of them are. I have Senate Bill 163, and I show LC 413012S. It's the version that passed the Senate. I don't know how much detail you want me to go into in full committee. I know we had this in sub last week, but what we're doing with this bill is providing a way for continued waiver of speedy trial, statutory speedy trial, beyond the public health emergency, beyond the judicial emergency, with the goal being hopefully soon we're going to see the public health emergency and at the same time the judicial emergency expire. And in that, while we had the right to demand speedy trial statutorily waived during that time, or told during that time, we want to have a bill that set forth the structure that makes sure that beyond that, for the next couple of years, we can orderly try criminal jury trials without the ability of folks to play games with filing demands just to try to get dismissals or to get ahead in line versus making sure we're trying the older cases first, for example, those that are incarcerated first. And so this bill came from the work of Judicial Council in what we call the off season. All the players came together involved in the criminal justice system and carefully drafted a bill that provides a way where local chief judges of state and superior courts can file certifications confirming that they do not have the ability to still have statutory speedy trial in place. And in doing so, they have to certify certain things such as their plan moving forward as to how to get criminal jury trials heard at that point. And again, I can go into more details if you want. Two things that gave, I'd say, me and others in the Senate comfort with this bill in looking at, we understand how important, of course, speedy trial rights are in our state. This bill, of course, does not in any way waive the constitutional right to speedy trial, but we want to make sure this is not something that courts or prosecutors or whoever's involved can sit on, make sure that we are trying cases as quickly as possible around the state. And so the two checks on that is, one, there's a right for a direct appeal, even on his or her own regard for the Chief Justice of the Supreme Court to overrule a local decision on this. And lastly, we put a sunset on the entire measure for 2023. That way we have to come back as a legislature and look at this again and see if we still need to have this still in law beyond that point. So with that, Mr. Chairman, I'll be happy to take any questions or walk through any parts of the bill you want me to walk through.
All right. I will also, hopefully to help the committee, I'll just let the members know we do have a House substitute to this bill that reflects some of the discussion that we had. And Chairman, I know that your committee is starting soon. And so if you need to get up
Okay.
and go anytime, but that's at the end of line 74. The or was turned to and, was changed to and. And originally the language for these factors was one or more, and that one or more was removed from, I'm now back on line 58. So now it just reads judicial emergency due to the following factors rather than one or more. Okay. So those factors will have to be considered in any order. And then finally, there was a time period that was in originally that the period could not be double the previous judicial emergency. Due to some confusion about that, we just took that out with the sunset in. Chairman Oliver.
I'm happy to vote for this because of your sunset provision, and it's assume that's fairly securely going to stay in it throughout the discussion. Also, I've been texting with Chairman Evstration about the idea of putting together a plan, a budget plan, 2-year budget plan, using stimulus money to deal with the backlog. And I think you and your partner, Andy Welch, would be great chairmen of that plan. I really think this is a very good example of how many of senior judges and extra resources on the prosecution and defense side could deal with this backlog in 2 years.
Yeah, I agree.
A good plan is what I'm asking for from the leadership.
Awesome. Thank you.
Representative Walensky.
Thank you, Chair. Thank you. Hello, Chair. The only question I had, and if you'd be all right with it, and I had a committee substitute drafted, but we only did one word. On line 94, it reads, 93, 94, the plan shall establish an order of priority in which such cases will be called for trial, giving highest priority to such cases, talking about cases that held in custody for the longest time. And I just want to remove the word highest, just so it's giving priority, because to me, when you have the word highest in there, it gives the implication that there's other priorities, and I want to make sure that this is the priority. Just your thoughts on that, and Chair, at the correct time, I'd like to make that motion for that amendment if possible.
And this, just make sure I'm clear, this is in the certification that's issued by the chief judge of the circuit, correct? This is what's included in the certification.
Yeah, and this is laying out how to prioritize, and this is the only priority listed in the whole bill.
Right.
And so when it said highest priority, I read that as an implication there are others. So
Maybe what we'll do is we will give some time for amendments later. I know Chairman Strickland has to go to the Senate Judiciary Committee meeting, but if we're going to debate amendments, we can take that up at the appropriate time.
The only thing you may want to do is the folks from Judicial Council are here outside in case they have any. I don't see any reason why we couldn't strike that myself, but in case I'm missing something, because they spent the months working on this and I've spent the weeks working on it. So that's the only suggestion I might have, Mr. Chairman.
Yes, sir. That's a good one. All right. Any other questions for Chairman Strickland? Seeing none and no one online. Thank you very much for being here,
Thank you.
Chairman.
Appreciate y'all.
All right. So bill was heard in subcommittee. So Chairman Gunner, do you want to give us a report about testimony heard in subcommittee and the recommendation given?
Recommendation was due pass out of the subcommittee. There was some discussion about the amendments that I think the chairman's already gone over with. So that would be my report from the subcommittee.
Very good. We are going to invite the Judicial Council in to join us and provide any input if they'd like to do that. Well, thank you so much for being back with us here today. If you all wouldn't mind just introducing yourself, and then Representative Walensky has a specific question for you.
Good afternoon, Mr. Chairman and members of the committee. My name is Tracy Mason with Judicial Council.
Good afternoon. I'm Darren Ants with the Judicial Council as well.
All right, Representative Walensky.
Thank you, Chair. Thank you all, Judicial Council, for being here, and all y'all have done. The bills y'all have done this year are very amazing, and our state will be in a much better place after all these. I just on line 94, and I spoke to y'all in the hallway at one point. Did y'all find out why they have the word highest in there, and are y'all okay with it just saying establish an order of priority in which such cases will be called for trial, giving priority to such cases of defendant, not highest?
This particular provision here was, we worked on this with Gactyl to try and make sure that the people who are in custody are getting what we consider the highest priority, because they've been in custody, and as opposed to other people who are out of custody. So that was our original intent. Giving priority, I understand that still has the same sort of connotation, but in our mind, the clearest, most unambiguous language would be highest priority.
All right. Any other questions for representatives from the Judicial Council? All right, seeing none. And just to be clear, the committee substitute that I presented today is LC 413103S. Maybe another draft floating around out there. All right, at this point in time, I'll hear a motion if there is one. There's a motion and a second. Any amendments?
No, I'm good. Thank you so much.
Okay. All right.
With me.
All right, I don't hear any amendments. Any amendments from anyone online? Very good. Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? No. All right, in the opinion of the chair, the ayes have it. Bill's under rules. Yes, sir.
Senator Brass is here with the bill, and I know he's supposed to be presenting the bill in front of one of our other committees, and I think he had a question about whether he could go and come back, or what the chair's preference would be.
Well, Senator Brass, if you'd like, we can take you right now. Yeah. Yeah, if you want to come on up.
I don't mind coming back.
That's fine if you want to come on up. All right, Senator, when you're ready, if you present Senate Bill 32.
Thank you, Mr. Chairman. Representative Fleming, thank you for letting me jump up here. It's pretty simple. Current law allows city, county, state employees to be exempt from public records. We're simply adding federal employees, and that's the bill we sent over from the Senate. We added a second section, which is actually now Section 1. This is where there's a little glitch in the Secretary of State system, that you can actually look up anybody that's getting a license through the Secretary of State's office. You can look up their home address online through his website. So we're simply fixing that little loophole in the law as well. That came from Representative Gullett, that he had been working with the Secretary of State's office, and they just didn't get a bill out, alleged counsel, in time to get it on. So I allowed him to hitch a ride, so to speak. So that's it.
Any questions for Senator Brass about Senate Bill 32, LC 364783S? This came through the Scoggins Subcommittee, I believe, and received a due pass recommendation. All right, is there a motion? Is there a second? Any amendments, discussion? Hearing none, all those in favor signify by saying aye. Aye. Any opposed? All right, it's on to rules.
Thank you, Mr.
Thank
Chairman.
you, Senator. All right. Senator Tippins, will you come on up, please? Senator Tippins, how are you today?
Doing fine, Mr. Chairman. Hope you are.
So we are going to hear Senate Bill 143, and I understand the request was for your other bill, Senate Bill 120. We put that off from today. Is that correct?
I'm fine with the discretion of the chairman.
And who is your House sponsor for Senate Bill 143?
Representative Jones.
Yes, sir. Todd Jones?
Yes, sir.
All right. If you'd like to present 143.
Senate Bill 143 has a one-word change to the underlying subject matter that was passed overwhelmingly with both chambers last year had to do with the lien law. If you look on line 72, the word lien in this context was supposed to have been stricken and the affidavit was inserted in its place. There was an oversight and lien was left in. This bill corrects that, strikes the word lien and inserts affidavit. The rest of the law remains unchanged.
Any questions for Senator Tippins? I don't see any questions. There's a motion to pass and a second. Any amendments or discussion? Hearing none, all those in favor signify by saying aye. Aye. Any opposed? Very good. The bill's on the rules. Thank you for being here,
Thank you very
Senator.
much, Mr. Chairman.
Yes,
and
sir.
committee.
Thank you. All right, Senator Dixon, I know you were in the hall. If you'd like to head on in. Mr. Leader, good to see you today. I'd like to come on forward. And when you're ready, go ahead and present Senate Bill 34 to us.
Thank you, Mr. Chairman. This bill, it simply allows victims of human trafficking to petition the court to allow for a name change under seal. It also allows the court to waive the requirement of publication in the paper. And then it also it allows the court later on to unseal petition or order a redaction of the petition later on if they see fit.
Any questions for Senator Dixon? It's a good bill. Motion to pass and second. All those in favor signify by saying aye. Aye. Any opposed? It's on to rules. Thank you very much for being here today. Chairman Gunner, I understand you're standing for Chairman Larry Walker today to present Senate Bill 169.
That's correct.
All right. Well, when you are ready, we'll hear from you.
I am mic number 10 if y'all.
Yes, sir. Gotcha.
Okay. Thank you. Senate Bill 169 is the surety bond bill. In this, due to the executive orders from the governor's office allowing for video conferencing and other electronic means, this also allows for electronic signatures and electronic corporate seals for the surety bonds. That's basically what it does.
This one came through Chairman Scoggins' subcommittee, I believe, received a due pass recommendation.
Yes, sir.
Are any questions? Hearing none, I'll hear a motion. Motion do pass. Is there a second? All right, any discussion or amendments? Hearing none, all those in favor of Senate Bill 169 signify by saying aye.
Aye.
Any opposed? Bill passes unanimous. On to rules. All right, next bill is Senate Bill 200. He knows. Senator, good to see you today. If you'd like to come on forward. All right, so we've received a committee substitute. Just want to make sure we all have the same draft in front of us. This is LC 471004S. Is that correct? All right, well, when you're ready, Senator, please present Senate Bill 200 to us.
Thank you. Thank you, Mr. Chairman and committee this afternoon. Senate Bill 200 creates a pathway for businesses and churches to stay open under modified operations during a state of emergency, provided it follows all precautions, procedures issued in the state of emergency ordered by the governor. This bill was brought to me by the National Federation of Independent Businesses and is supported by several organizations across the state that represent the business community and the faith-based community. With that, Mr. Chairman, I'll take any questions.
Any questions for the sponsor, Representative Walensky?
Thank you, Chair. The free exercise of religious beliefs, in our Constitution and everything that I've learned, it's very, very, very broad. Does this narrow in any way, or is it just literally the broad term of any free exercise of religious beliefs?
Yeah, this bill is not intended to narrow that in any such way.
All right. I see Representative Wilson has a question online.
Thank you, Mr. Chairman. Can you hear me?
Try again. Will you give us a test?
Check.
Yeah, we got you.
Thank you, Mr. Chairman. Senator, I'm sorry, I'm just trying to pull up the substitute here. On line 14, it references religious institution. Is that defined somewhere? It's not in the bill. I'm asking if it's somewhere else in the law, maybe.
I would need to double check, but I believe the way we wrote this is basically referring to the other institutions or organizations we've referenced in lines 13 through 15. So institution, and just in regards to, I think any sort of faith-based organization that would have the same credence as a church.
What is the concern? I'm sorry. Go ahead.
No, go ahead. I'm sorry.
What is the concern that given the recent Supreme Court rulings in this area of law, what is the concern that the First Amendment does not protect houses of worship?
I think basically what we're trying to accomplish here is I've talked to other legislators about is just ensuring that we are absolutely just protecting the free exercise of religious beliefs during a state of emergency or otherwise.
And Mr. Chairman, just one more follow-up, if I may.
Yes.
Senator, my understanding of the recent Supreme Court rulings is that the Supreme Court has said or has recognized that states do have the ability under the First Amendment to impose limitations on houses of worship or religious gatherings, so long as they're treated comparable to secular activities, for example. Is that your understanding of what the state of the law is? So this would actually move farther than that and say the state actually cannot impose any restrictions. Is that right?
Thank you for the question, sir. We brought this bill here to basically protect religious institutions and just want to make sure that during a state of emergency, those rights are upheld.
Are you able to speak to the current state of the Supreme Court case law?
Sir, I'm an average citizen from senator from West Georgia. I'm not an attorney. I'll let y'all have that legal debate.
Thank you, Mr.
Chairman Oliver.
I must have missed something. I thought this was only about religious institutions. Did the substitute create the business exception, or did I miss this?
It's the business discussion is lines 17 through 21. So the main difference between
Was that in the original bill?
it is in the original bill. So Representative Oliver, line 17 through 21, the difference between the substitute and the original bill is in the original bill. Basically, we just used the word business. In this one, very similar to Representative Carpenter's bill that I believe came before this committee. We added the language of establishment, nonprofit corporation, organization, and corporation or other entity to the substitute.
Any follow-up?
No.
All right. Any other questions for the sponsor? Yes, Representative Evans.
Thank you, Mr. Chairman. Senator, my questions are in about line 17 through 21 on the business side of this.
Yes, ma'am.
if an executive order comes out declaring a state of emergency, but it doesn't have specific criteria for safety precautions and procedures that need to be followed, would it be your opinion that this bill is intended to say that any business can just go about doing their things, doing their business because the governor didn't set forth specific precautions, or if there aren't specific precautions set forth in the emergency declaration, then there's not a way for them to operate outside of our normal essential business rules?
That's a good question. Thank you for the question. So yeah, so basically, if there are applicable safety precautions procedures that are listed in the executive order under a state of emergency, basically the business community or small businesses, so long as they comply with what that said order is, would stay open. I don't know if I can really guess as to, unless we're in the middle of another pandemic or Cat 5 hurricane that hits the Georgia coast, if God forbid that never happens, there's circumstances of what the governor issues at that moment in time during the state of emergency. This is basically just creating a pathway so that if certain procedures and precautions are put in place by the executive branch, that the businesses do have a pathway to stay open.
So the governor would have to trigger that ability, though, by specifically setting forth precautions and criteria. It wouldn't be that if he's silent, then everybody gets to go on and do whatever they want to do.
Well, my own personal opinion is that I think if the government's silent and I own and run a business, I'm going to do whatever I have to do in order to take care of my employees, my family, make sure my business is safe, and kind of, for my own circumstances, make those decisions for my business to, stay open or shut. I think during those situations.
I think I'm not being as clear as I mean to be. If the governor says, similar to what happened in this COVID situation, we're essentially shutting down. In the law as it is right now, the governor says everything shuts down. It shuts down unless you're an essential business. Then you get to continue. I'm asking if the governor says we are shut down, and that's all he says, and he doesn't set out any particular criteria, does this bill allow businesses to go about their daily operations because the executive order did not specify things they would need to do to stay open?
Yeah. I mean, I think the way I answered the question just previously, I think kind of answers that question.
Well, I'm not trying. I'm literally trying to get information so I can vote on your bill. So I would appreciate you trying to help me out. I'm not playing gotcha. I'm literally trying to get information. So I didn't think your answer answered it, or I wouldn't have asked another question. So essentially, this could make an executive order declaring a state of emergency toothless.
I would respectfully disagree,
but you're saying that businesses will be able to do their daily business operations unless and until the governor set forth criteria for them to stay open under. But if he just said, we need to shut down, I need to say this right now because we don't have time, and I'm going to come back later and put precautions, that order would be toothless.
Yeah, I can't sit here and pretend to know what's going to happen in that situation based on the lessons learned. I think under what we've seen in Georgia and what we've seen potentially happen in other states across the country, where businesses with low cash flow and other circumstances were forced to shut down. If and when procedures and safety protocols are put in place, this is creating a pathway for them to stay open.
One more question, Mr. Chairman.
Yes, ma'am.
Are we setting up a situation, though, where a business could stay open, and if we pass this measure, they would be lawfully allowed to do essentially whatever they wanted to do, but we could be setting up a situation where the patrons would be violating the law by being out in a declared state of emergency where we've been under a lockdown order?
I think under the circumstances, if there are certain precautions that are issued by the governor, and if there is in fact a pathway for businesses to stay open, I think in that situation, I could only assume that individuals or patrons must be allowed or would be allowed to go to those businesses.
But this bill doesn't address that directly.
I'm here to address small businesses and churches.
Thank you.
Chairman
you.
Fleming.
Along the lines of Ms. Evans' question to you, if the order says shut down, but it provides nothing to comply with so you can stay open, you shut down, correct?
Yes, pretty much.
Simple.
Chairman Burchett.
Thank you, Senator, for bringing this piece of legislation. Mine is just kind of in the same line as that question. The way I read it is that if and when there's a declaration, if there are any applicable standards or safety precautions and procedures, then they may remain open. But if they're not, if the order is, and at that time, the governor has pretty expansive powers. If he tailors the order to be shut down, regardless of what's on the books, with no safety precautions, then I would read it to say they would shut down. I just wanted to add that.
We have a question online from Representative Holcomb.
Thank you, Mr. Chairman. My question's on the religious side is, what does it mean specifically limited? Line 15.
Thank you for the question, Representative. Basically, what we're trying to accomplish with line 15 is just to ensure that the inherent right to assemble and practice our faith remains in place during a state of emergency.
Okay. We considered a measure on this before, House Bill 536, and I think that language is cleaner, and it states no power granted under the provisions of this code section shall be utilized to specifically limit the practice of any religion. So it still uses specifically, but it just modifies it to limit the practice of any religion. And that seems to be a lot clearer to me, which was to just address this issue of religious communities should not be treated dissimilarly from any other businesses and entities, which my understanding is that took place in other states, not here in Georgia, but in other states. So do you have a reaction to that, or would you be averse to changing it to the language that was in 536, or are you wedded to this Senate draft?
I'm wedded to the Senate draft, but I'm at your mercy here before the committee. So whatever you and the chairman want to do and the rest of the committee.
Chairman Oliver, you have a follow-up?
Yes, sir. Am I correct that Chairman Fleming and Chairman Burchett gave different answers to the same question that was posed? I think, okay, well, let me, wink, wink, okay.
Madam Chair, if you have a question to the sponsor, this would be the appropriate time. If you want to have a discussion amongst us on the committee, we'll do that later.
Thank you, Mr. Chairman. I respect that Speaker, the Senator is really inviting us to have a discussion about how this changes the United States Supreme Court case. Is that accurate, Senator?
As I've come before other judiciary committees, I'll with any piece of legislation, let y'all lawyer it up. If there's, if y'all have suggestions, I'll leave that kind of at the, the behest of the chairman and the committee.
I'm just curious, Mr. Chair, if anybody has an opinion that they feel confident stating, whether or not this changes the United States Supreme Court decision.
We have 2 witnesses signed up to speak on this bill. So, Senator, if you'd like to use one of the other chairs, we have chairs in the back with microphones. Tell you what, if you'd like to stay there, we can actually have our witnesses come back in. So, all right, first witnesses is Christopher Bruce. Hello, good to see you today, Mr. Bruce. If y'all like to have a seat in the back 2 chairs back there, and if you'll just tell me your number with the microphone. Very good. And Mr. Bruce, there is a chair next to you. Yes, sir. In case you want to provide any testimony as well. So, yes, ma'am. Thank you for being here today.
Thank you very much. Thank you for
Number 9. Use Representative Gunner's microphone.
Mr. Chairman and members of the committee.
Yes, thank you.
Thank you very much for this opportunity. I'm Andrea Young. I'm the executive director of the ACLU of Georgia. We, of course, are an organization that's committed to civil rights and civil liberties of all Georgians in all 159 counties where we have members and supporters. We came to speak out of concern for this legislation. Of course, people of faith and their right to exercise their religion is protected by the Constitution. But we find that the original version of this bill was much more extreme than the Supreme Court's recent rulings. We're a little unclear as to the implications of the substitute. As Senator Oliver has raised, is a question of, we would find it important that obviously this be within the context of the Supreme Court's decision in the California case regarding worship. There's also some concern as to whether or not the language is sort of backing away. There's sort of two versions of it. That one sort of states the obvious, is that churches, as my church during COVID, has followed the guidance, health guidance, and that churches would not be, in places of worship, would not be singled out for any particular constraints that were not common constraints to any other institution serving the community. And I think, if that's what this language implies, I think that's fair. I think that states the obvious. It's hard to imagine a leader in Georgia doing something that was intentionally interfering, with the right to worship. And then there's the clarification about then the sort of reiteration of applying with all applicable safety precautions, just to want to be clear that that means the precautions that are in the new emergency order, that orders that are made pursuant to a state of emergency or, other situation that which again seems a little bit to be redundant, but as long as it's clear that that's not carving out any kind of an exception or referring to pre-existing safety precautions rather than the ones that have been issued pursuant to the state of emergency. Hopefully none of us ever have to live again under the kind of constraints we've had with COVID-19, but it's important for public safety and the well-being of all of our citizens. And I think the leaders of our faith communities also rely on that on tailored advice as to the best way to protect the health and safety of the members of their community. And so we would want to make it clear that all of these things are done in a way that is treating everyone the same and never disadvantaging anyone based on their faith and religious practices, but that people follow standard guidance that's meant to keep the public safe.
Any questions? Representative Jones.
Thank you, ma'am. I share your aspirational goal, and I say this with complete respect. But after what I saw across this country, I just can't believe I was in the United States the last year in terms of casinos being allowed to open when houses of worship weren't. when certain institutions were allowed to do certain things and houses of worship weren't. So I share that aspirational goal that you have. So as you're looking at this, and I do mean this respectfully, do you consider a change in any of this language? I know you're here as a witness, not as the bill sponsor,
Right.
but we both are trying to get to the same place. I don't know if you share my opinion or not of what you, what I saw was seriously abhorrent to me in this country. So anything that I can do to help the state of Georgia not ever experience what was experienced by some of the states in our union, I want to make sure we do that. So what are your thoughts?
I think that your question goes really just to just confirming that the plain language is what is intended, that places of worship should not be treated differently. And I think that's certainly a standard that we would share. And as the ACLU, we would certainly be opposed to people being singled out because of their faith, if rather than the circumstances of for example, if there's a prohibition on gatherings over 50, that's applied, that is not, that churches and other places of worship are certainly not singled out, and other organizations allowed to violate that standard, that these would be standards that would apply regardless of the kind of entity, but something that was a standard based on safety for the public.
Thank you.
All right, I don't see any other questions. Thank you very much
Great,
for being
thank
here
you.
today. Mr. Bruce, anything you wanted to add? All right. Yes, sir. Thank you for being here. All right, next witness we have signed up is Samantha Fillmore. She'll come on in, please.
Hi, can y'all hear me? I'm testifying via Zoom.
Yes, we can hear you. Please go ahead.
Wonderful. Thank you, Chairman and members of the committee, for holding a hearing on Senate Bill 200 today. My name is Samantha Fillmore. I am a state government relations manager at the Heartland Institute. We're a 37-year-old national nonprofit think tank primarily based on free market ideals. I ultimately just wanted to draw your attention to something mirrored earlier in this conversation, but due to the coronavirus pandemic, we saw many states watch helplessly as their governors wielded broad emergency powers. And Senate Bill 200 is a very good step in the right direction to begin to curb that unilateral power for constituents in your state. We saw lawmakers, we watched all across the nation as some states had tremendous successes in managing the government response to the pandemic, while other responses were haphazard and seemingly without rhyme or reason. Regardless, in any case, the governors acted with little to no input from the legislative branch, thus effectively removing the people from the equation, because you, the elected representatives, are chosen from your communities to represent the very people who put you into office in your great state. We've seen the worst cases of gubernatorial overreach in states like California and New York, and if governors are left unchecked with unilateral control, we see that they can make decisions that may decimate states' economies, small businesses, and impede citizens' rights. The concept encompassed by Senate Bill 200 is straightforward and necessary. It restores autonomy back to lawmakers, religious institutions, and businesses. Yelp estimates that 60% of small businesses are permanently closed due to the coronavirus pandemic. Ultimately, this stands by a principle that the Heartland Institute developed last spring, if and when governors begin to abuse their newfound powers. And Senate Bill 200 abides by one of those specific guidelines, which is limitations on executive authority during emergency proclamations that would restrict the governor from unilaterally closing businesses, house of worships, or shutting down freedom of press, all other things that may be concerning. Based on this legislation, it's clear there is an appetite among lawmakers in your states and constituents to reinsert themselves back into the debate and create mechanisms that would ensure the protections of Georgians and their right to worship, as well as own and maintain small businesses. Co-equal governance is a bedrock of the American principle, and through this legislation, you, the Georgia lawmakers, have an opportunity to reassert yourself back into that and set an example for tens of states that are also considering legislation like this around the country. So thank you for having me and listening to my testimony. If you have any questions, I am available. Thank you, Chairman.
Any questions? Hearing none. Thank you for being here today to testify. So we have two more witnesses who are signed up, Mike Griffin, Nathan Humphreys. If they would like to come on in the room, we will have you up next. Yes, Sir, if you'd like to have a seat and just tell me which number you're, yep.
Thank you, Mr. Chairman. I appreciate this opportunity. And we appreciate the senator and his sharing this bill with us. Georgia Baptist Mission Board supports SB 200. The Georgia Baptist Mission Board represents approximately 1.4 million Georgians, approximately 3,600 churches. We are the largest denomination in the state. And we're very thankful for our government and our governor, the way they have worked through these very difficult times. We appreciate this committee considering this legislation because I know y'all are very detailed and very concentrated to make sure everything is done right. But our churches appreciated Governor Kemp and the way he put personal responsibility and rights on churches and individuals to make good decisions. He set up proper guidelines, and it was the kind of thing that our churches and our pastors really appreciated. We're thankful that we live in the state of Georgia where respect for the First Amendment is a priority because it's a constitutional right. And we believe that our churches should, in case there is another situation that comes available, not be put in a position where Nevada or, California, other places, or New York, what they were put in. And we believe this kind of legislation is good insurance, should I say, for the future moving forward, that we continue to maintain those standards. We saw in our churches people acknowledging, and our pastors acknowledging, that they had the right and the responsibility to do proper health and safety measures, for the members to have the right and the responsibility to choose whether or not they felt like they should or should not attend. And our churches were willing to say to their members, you have that right and responsibility, and we respect that. And so many of our churches, they did. I mean, they all basically shut down without even being told to shut down, but they did it in a responsible way according to the guidelines that was given. And it's been a very good experience for us.
Representative Bruce has a question for you.
Yes, sir.
Yeah, I'm just trying to get clarity. The legislation, would this allow the churches to be open even if everything else was shut down and the churches just said, for religious purposes, we're gonna just be open and operate as normal? I'm trying to, is that what's happening?
Is that
Mr. Griffin? Yes, sir.
My assumption is that they would give that choice to the churches to remain open, not requiring them to be open. So this is you hardly ever hear me say I'm in favor of pro-choice, but this is pro-choice when it comes to the church making a choice with reasonable understanding of what they're up against.
Yeah, I understand the choice, but I guess what I'm trying to make sure is it giving them the ability to choose to be open at full capacity when circumstances say that we should not. This virus started out at a funeral service at a church, and not started out, but that's where it was first reported in Georgia. A lot of people got sick. So would this have the ability for a church to say, we know that it's dangerous, but because of our religious belief that God is going to look out for us, we're going to open up at full capacity anyway? Is that what this is doing?
Well, as you know, it's impossible to make a second first impression. And the first impression that this pandemic had was in a situation where people were not aware of it or knowledgeable of it. I don't think we'll ever go through that same experience again with what we have gone through. And again, it comes down to personal responsibility of those individuals that they don't have to go to church. And so that's a choice that they're going to make and the risk that they take. Just like, you know, on our churches right now, we've got signs up that says, if you walk in here, you're accepting personal responsibility for coming in and exposing yourself to whatever level you may think there's a virus in this particular environment.
So we have a couple folks wanting to ask questions, and I'll just tell the committee members, I'm getting some text from folks who have other committee obligations. I expect we're going to hear witness testimony on this today, but we're not going to vote on it this afternoon. And so if you need time to get clarity from the sponsor as to any of your specific questions about the language, you'll have an opportunity to do that before next meeting. Representative Bruce, that might be of assistance there. Representative Walensky, do you still have a question? Okay.
Thank you, Chair. I'll be brief. Just one quick question that, you know, the exercise of religion under our Constitution and our laws is about conduct and not belief. And I understand what you're trying to do, but do you have any concern that, you know, the broadness of the exercise of religion goes to, you know, perhaps Wiccans or activity that is protected, that is religious, that isn't, you know, what you may consider core religious beliefs, as in Muslim, Jewish, Christianity? Is there any concern there that it's conduct instead of, or just the broadness of the exercise of religion for this?
Is that for me or the author?
Well, he posed it to you, Mr. Griffin.
Well,
who
we know that the Constitution, Georgia State Constitution, has a public health and safety barrier against all religions not violating that. You're not going to be able to have human sacrifice. That's not going to happen. So, I mean, there are basic health and safety regulations that are there inside of the First Amendment that are required. And so, you know, when we're talking about respecting First Amendment in Georgia, we're talking about it in relationship to the way we're looking at it right now in our state.
Thank you very much for being here today,
sir. Thank
Mr.
you,
Griffin.
Mr. Chairman.
Mr. Humphreys can come on in now. Mr. Humphreys, thanks for being here today. And when you're ready, if you just identify yourself and tell us anything you want to share about Senate Bill 200.
Sure. Thank you, Mr. Chairman, members of the committee, for having me. My name is Nathan Humphrey. I'm with the NFIB. We represent small business owners in the state of Georgia. And really, we've introduced similar legislation in some other states as well, where we came with this. What we've seen during the pandemic is really incredible creativity from small business owners to adapt their business models to supply chain interruptions and all the other things that have happened with the economy, but also with the safety of their employees and their safety of their customers as well. And in some states, we've seen disparity in how the pandemic was governed, and it disproportionately hit small business. For instance, some big box store retailers were allowed to remain open, but small mom and pop shops that were selling many of the same products that were in those big box stores were closed. And unlike the big box store chains, the small mom and pop shops don't have the cash flow and reserves to survive a shutdown like we've seen. So thankfully, the way it was handled here in Georgia was great. Many of our small business owners were able to stay open, even though they had to adapt their business model, whether it was a dry cleaner, barbershop, restaurant. And we feel like this legislation will create a path for them to remain open, even if they have to adapt and make changes, that at least they have got the ability to have a fighting chance.
Any questions for Mr. Humphrey? All right, seeing none. Thank you very much. Oh, Representative Evans.
Thank you, Mr. Chairman. Similar to the question I was trying to ask the bill sponsor, are you asking for the ability for businesses to stay open unless the governor sets specific safety criteria and then they don't abide by that? Like if he were to set an emergency order shutting everything down and he didn't set out specific safety precautions, is this bill intended to let businesses go about their daily operations?
So to make sure, Representative, make sure I understand your question, they would be allowed to remain open if the governor, through executive order, put in certain, safety guidelines and things that the businesses would have to comply and adapt to that. But I think this is getting at is avoiding a unilateral, just complete shutdown.
But that's my question. If the governor issues a shutdown order and the business is not in the law as an essential business, but the governor's emergency order doesn't say, but here are 10 things you can do to stay open. If he's silent on that, under this law, would businesses be able to go about their daily business because there wasn't any applicable safety precautions and procedures contained in the order?
Well, I think that would be on the governor to address that. But our hope is that as many businesses could remain open as possible. Given the circumstances, they may have to adapt and make some changes. But I think the goal is to ensure as many of them can open as possible and stay open.
Thank you.
Mr. Kelly.
Thank you, Mr. Chairman. I guess my question is kind of in the same vein as Representative Evans, but from a different perspective, because I want to make sure the legislation is strong enough. What if in the governor's executive order, he said, or he or she said, it is in the interest of the state for no business shall operate for more than 5 minutes per 24-hour period? Would that be an applicable law that businesses would have to follow to comply? Because if that's allowed to be done, then I don't know if this does what we need it to do.
All right. I think that we've heard from all the witnesses who were signed up to testify on the bill today. And I think we've heard from all the witnesses who were signed up. Appreciate the discussion that we've had. And Senator, I thank you for being here today. We're going to hold this bill over today, have an opportunity for members to get with you to get their specific questions answered that they might have offline, but we appreciate you being here and making this presentation. All right, the final bill that we have on the calendar today is Senate Bill 75. Senator Jackson's in the hall. She can come on in. Hi, Senator. Good to see you today. I'd like to have a seat right up here, please. All right, and when you're ready, please go ahead and present Senate Bill 75 to us.
Well, thank you, Mr. Chairman, and thank you to the committee. It's good to be here. You have before you a pretty straightforward bill. This body, in fact, did something quite similar in 2018. What this does is it allows victims of stalking, people who have gone before a judge, received a temporary protective order, to be able to take that to their management, housing management, or their landlord, and then get out of their lease with 30 days notice so that they can move to a place of safety. This it parallels exactly the bill that we did before when it came to domestic violence. So it requires the same things. If it's an ex parte order, then you have to have a police report to accompany that. Of course, criminal stalking you would be eligible for that as well, for protections as well. So it's very straightforward, but happy to answer any questions.
Any questions for the senator? All right, we have 2 witnesses signed up on the bill. Nikki Leminska with the Georgia Commission on Family Violence.
Yes, thank you.
Hi, yes. If you'd like to go ahead, please.
Okay, you can hear me good. All right. Chairman Efstration and members of the committee, thank you for your time this afternoon. My name is Nikki Lemeshka, and I'm the program manager for the Georgia Commission on Family Violence. And I'm happy to appear today to relay the commission's support of Senate Bill 75. I have worked in the field of family violence for 20 years myself, in settings ranging from one-on-one advocacy for victims seeking temporary protective orders to navigating the state's coordinated community response. Since 2016, I have spent a lot of time working to cultivate expertise in the area of stalking. And it's in that capacity that I appear today, as this piece of legislation addresses a significant gap in protections for victims of stalking statewide. As a commission, we have made significant strides in the last few years to educate stakeholders, including advocates, law enforcement, prosecution, and many others, about the problem of stalking. And we focus on the fact that stalking is a prevalent problem in Georgia that's often hidden in plain sight. In fact, 4% of women and 2% of men are stalked each year in the United States. And based on those prevalence estimates, that means that roughly 312,000 Georgians are stalked each year. That's enough to fill State Farm Arena just down the road from the Capitol about 15 times every year. So stalkers today employ a variety of mechanisms to instill fear in their victims. Things like surveillance tactics, life invasion, intimidation, and interference through sabotage or attack. And almost half of stalking victims experience at least one unwanted contact per week, and the majority of victims are stalked by someone they know. This all takes a real toll on victims. In studies, roughly half of victims fear what is going to happen next, and a third of victims fear that the stalking will never stop. And truthfully, those victims have reason to be afraid. Stalking behaviors are widely recognized to be an indicator of increased risk of lethal violence. As the former coordinator of the Georgia Domestic Violence Fatality Review Project, I can tell you that when we started to take a closer look at stalking, we found that 58% of Georgia cases that had been reviewed by our fatality project since 2004 involved stalking behaviors. And that moved us to release a report in 2017 that focused on the issue of intimate partner stalking. Among the potentially life-saving recommendations included in that report was tenant protections, which allow victims to vacate a lease without penalty if they need to relocate for safety reasons. As Senator Jackson mentioned, in 2018, Georgia passed legislation to that effect for victims of family violence. And this was a huge step forward for victim safety, and the feedback from victim advocates in the wake of that change has really been excellent. Senate Bill 75 seeks to establish similar provisions as those previously enacted, but this time for the victims of stalking. So it's important to point out, as it pertains to lease relief, that these victim safety issues should also be identified as community safety issues. A specific victim may be the target of the abuse, but many others in the community are often victimized by proxy. And sadly, it's not uncommon for these patterns of stalking to continue for many years. These behaviors cause 1 in 7 stalking victims to move as a result of the victimization. So I would actually imagine that number would be higher if it were up to victims, but for them, seeking protection from abuse can be financially draining and limits their ability to relocate to safer housing. If victims are engaged in the civil or criminal court system, for example, they're often required to miss work to address issues created by their stalker. And add to that the cost of relocating, and those barriers to safety really start to act up or stack up. So enabling tenants experiencing stalking to move out quickly and without penalty will not only create a better path to safe housing, but will reduce the likelihood of potentially lethal violence in communities around our state. Thank you for your time.
Thank you. Have a question from Chairman Fleming. Oh, okay. Thank you very much, ma'am. We have one more witness signed up, Ms. Marina Peed, who's here in person. Oh, yes, ma'am. Thank you. Actually, if you wouldn't mind, we're having problems with that microphone. Will you scoot over to number 10, please?
And I have been vaccinated and I'm tested negative for COVID. So I'll be brief, but thank you, Mr. Chairman, and all the members here. My name is Marina Peed. I'm the Executive Director of Mosaic, Georgia. We're the Sexual Assault Center and Children's Advocacy Center serving the judicial circuits of Gwinnett and Rockdale County. And I'm here today to share support for this legislation. We do have some civil legal services for victims who have experienced some form of sexual crimes, and we have had occasion where it is for their safety a need to relocate. We have negotiated some things with landlords on a voluntary basis, but it strictly is on a voluntary circumstance. So allowing this provision will make this easier, not only in our community, but in other communities across the state where victims may not have access to attorneys to help them with their safety.
Any
Thank you.
questions for the witness? Thank you very much for being here today.
Thank you.
We have Mr. Stanley, who is in the back.
Thank you. Good afternoon. My name is Hayden Stanley. Represent the Georgia Apartment Association. And as the industry did several years ago when the provision regarding victims of domestic violence was added to the law, we support this change to the law as well. We believe that it is drawn sufficiently tight to allow those victims of stalking under judicial order or ex parte with police report to make the changes that they need. Our owners and managers most often work with those residents that find themselves in that situation. And so we're glad to support this legislation.
All right. Thank you very much to our witnesses for being here today. Chairman Fleming.
Thank you, Mr. Chairman. On line 60, to the author, I believe, on line 60 through 62, why are we striking that?
Yes, sir. So this is to bring us into compliance. In Georgia, we can't make any modifications to existing leases. So it won't, if you turn over, this law won't go into effect on leases until July 2021. So we struck the 2028 provision, which was a part of the original domestic violence lease release program. And now we've updated that to go into effect on July 1, 2021.
So where is the law saying that we can't affect prior leases that have been entered into?
That's all of the legislative council has said to me that was what's required, that we can't retroactively. So if you're in a lease right now today, we as a body cannot modify that lease. So it would be all for new leases going forward.
Why did we put this in the bill when we passed it 2 years ago?
For that reason, so that it would go into effect on July 1 of 2018.
No, it says, what you're striking says this code section shall apply to all residential real estate rental or lease agreements entered into owner after July 18th.
That's right. So
this July 1st, 2018.
Right. So this body passed this bill in March of 2018. And what we struck was that would go into effect for leases only on July 1 and thereafter. So we're doing the exact same thing. The law will not go into effect and impact leases until July 1 of 2021.
Your answers you have in section 2.
That's correct. Yeah,
Okay,
it's on the next page. That's right.
Okay, that would have covered me when I asked it the first time. I'm sorry, I must have not asked the questions well. I should have.
It's okay.
Second question, if I may, Mr. Chairman.
Yes, sir.
Does the stalking have to be related to the residence of the individual?
No, sir. The stalking order has to be tied to the person themselves. And I can say a little bit more about that. So what we've learned, and thanks to the Georgia Commission on Family Violence for providing a significant amount of information on this, is that while stalking may not begin at the person's residence, that over time stalkers tend to ultimately end up at that person's residence or having somebody by proxy stalk the person at their residence.
Any idea what percentage of stalking orders involve residences?
No, but we do know that 1 in 7 people who are victims of stalking do find that they need to move.
Where does that information come from?
From the Georgia Commission on Family Violence.
Thank you.
Representative Kelly.
I just want to make sure I'm looking through this and certainly support the bill and its principle. I'm just trying to make sure, because I had a concern that's the same as Chairman Fleming. And so this will be effective on July 1, this legislation, if it's signed by law by the governor. And so then it would only impact those moving forward. I'm just making sure that we already have certain agreements for civil, provisions for civil family violence, criminal family violence. I'm just making sure that we don't end up limiting an ability for someone to break those leases between now and July 1. And so I guess the effective date of the overall bill will be July 1, and
No, sir. So the pre-existing, because those things are already in effect, the domestic violence piece is already in effect. This would not have an impact. It would only impact this new portion around criminal stalking, civil stalking, TPS.
Okay.
Chairman Burchett.
Senator, thank you for bringing the legislation. I got a quick question. One, I guess this works for any protective order. So family violence protective order, you can do this too. You can.
That's right. And that actually predates this. The 2018 legislation made it possible for a family
Sure.
violence order.
So are you aware of the legislation that we're working on for a dating relationship?
Yes, sir.
Do you expect that that's going to fall within this?
I believe that the dating relationship is creating a separate code that's outside of the family violence section. And therefore, they would not be covered under this. We would have to come back and do another cleanup bill to include those. That's my understanding of the bill as it stands forward, but please correct me if I'm wrong.
Okay, I just wanted to know if you knew. I don't know, to be honest with you. We are creating a new section, but I think it would fall under the title and chapter that you have here. So that's what I was wondering. I appreciate it.
Thank you.
So question to Mr. Tolbert, who's with us online. I think Representative Kelly's raised an interesting question here. Do you view passage of Senate Bill 75 as proposed here as creating any potential gap between now and the end, now and July of this year that would potentially cause a victim of family violence to be unable to break his or her lease because of the language around the effective date in Section 2 of the bill?
Mr. Chairman, I do not think that it would create a gap because the current law is already in effect and is already protecting those who are covered under family violence. What we're doing in this bill is saying that the effective date for the stalking piece, that's what line 65 through 67 is addressing here. So I don't foresee there being a gap created by the passage of this act.
Questions, Representative Kelly?
No, I was just making sure I didn't talk myself into an issue, because I didn't want to, mess up for sure the others. But I guess if everything's becoming effective on July 1, essentially the effective date of the bill would be July 1. And then you would talk about any leases moving forward on July 1, anything before it wouldn't have an impact on. So I think my question's been answered.
So the hypothetical is that if someone entered into a lease, let's say in December of 2020, and that person then was pursuing let's say a family violence protective order, or had a family violence protective order, that person would not be able to break the lease because the lease was not entered into on or after July 1st, 21.
No, that's not quite. So in your scenario, if someone were in a lease in December of 2020, they received a family domestic violence order. Under the current existing law, they would be protected. This law doesn't go into effect until July 1st. So that part of the code doesn't get stricken until July 1st. Does that make sense? So until July 1st, until the governor signs this bill on July 1st, everyone is covered under the existing law, which would therefore cover people who have family domestic violence orders. But starting July 1st, any new leases would include civil stalking orders as well.
Senator, I'm in agreement. This act shall apply to all residential real estate rental or lease agreements entered into after the date, on or after the date. And the way I read it, that lines up. So I'm in agreement. I don't think we have an issue there. And I appreciate Mr. Tolbert weighing in. Did you have further comment?
Say the same thing, Mr.
Yeah.
Chairman. I think we're in good shape, and at the appropriate time, I'd like to make a motion.
That's the appropriate time.
Move to pass.
Is there- All right, very good. Any discussion or amendments? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Senator Jackson, you've just received the judiciary treatment here in the House. So a lot of talk about one little section of the bill, but thank you so much for being here. And your bill's on to the House Rules Committee. If you'll just fill out a rules request form,
I've
I'll
got
sign
that
it.
for you.
Perfect. I'll sign it now. Yeah. All right, adjourned. Thank you.
Thank you.